The purpose of this podcast is to educate our listeners, and it does not constitute professional advice or services. The legal areas, services, law and process discussed are relevant at the time of recording, and it is important that you seek independent legal advice on such topics to ensure that the law has not changed or been updated in relation to the area of law you need advice on or are interested in.
Court is in session.
Hello and welcome to the first episode of Lawyers Who Lunch. I am your host Sophie.
And I'm Lydia.
Today we're diving into something big and honestly kind of everywhere in our lives. The history of law in the UK and how laws are actually made today.
Yeah, this is one of those topics that sounds intimidating, but once you get into it, it's actually full of drama. Kings, rebellions, executions, people arguing over taxes, it's basically one big soap opera.
Exactly, and the UK legal system is still one of the oldest still in use. A lot of countries base their systems on it, and even though the UK itself doesn't have a single written constitution.
Which always blows people's minds, mine included. No one big rule book, just centuries of decisions, arguments and compromises stacked on top of each other.
So today we're going to look at where UK law comes from, how it developed, and then importantly, how law is actually made today, step by step.
You don't need any legal background, you just need curiosity.
To understand UK law, we're going to take you way back, way before Parliament, before the courts, and even before England really existed.
Early medieval Britain had no single legal system. Law was local, tribal and often violent. So if someone wronged you, you didn't sue them. You either got revenge, demanded compensation, or your family handled it for you.
Right, so crime was an offence against the state. It was an offence against you and different groups. Anglo-Saxons, Vikings, Celts, and they all had their own customs.
And none of this was written down.
Nope, laws were just spoken. Memory mattered, but that all changed in 1066. In 1066, William the Conqueror invades England, wins the Battle of Hastings and becomes king.
And this is relevant for law because he centralises power. Instead of dozens of local justice systems, the king becomes the main source of authority. He sends judges out all across the country to hear cases and crucially start deciding similar cases in similar ways, which is where common law comes from.
Common meaning common across the land. Judges look at past decisions and follow them.
That idea is called precedent and it's still a massive part of the UK law today.
At this point though in the UK, the king still had huge power. People didn't like this and they started pushing back.
In 1215, King John is now on the throne, but he's deeply unpopular. He introduced high taxes, has had failed wars and is ignoring tradition. He was not a fan favourite of the people.
The barons rebel against his shocking rule. The rebellion saw King John offer the Magna Carta as a compromise, and this is the first written document that established that everyone, including the king, was subject to the law.
It forced King John to limit his power, prevent exploitation, and saw the introduction of key rights such as fair trials. However, it's not a human rights document in the modern sense.
But it does introduce a revolutionary idea that the king is not above the law, as shown recently by Prince Andrew's arrest, where he was arrested for misconduct in public office in relation to the Epstein files.
Things like fair trials, limits on punishment and lawful judgment was established. Although the Magna Carta was breached and another war broke out, the symbolism of the Magna Carta left an imprint that shapes the foundation of our laws today.
Over time, another key institution then grows. This is known as Parliament.
Parliament didn't just appear overnight and it wasn't always part of the legal framework. Originally, an advisory council for the king who consulted nobles, church leaders and landowners is very exclusive and not very democratic. Over time, as society evolved and wars broke out, the monarchy needed money and commoners had more of a say, particularly about taxes. This led to the two-house system being developed, the House of Lords and the House of Commons, the system we still use today.
The House of Lords is made up of nobles, bishops and people with titles. It's an inherited title, basically. The House of Commons is made up of elected representatives for different constituencies. Actually, I'm going to interrupt you now before you go on, because there is talk of removing House of Lords being an inherited passed on title. They're actually looking at removing it, being able to be passed down from generation to generation.
Yeah, you have to earn it.
Yeah.
For centuries, power has constantly shifted between the monarch, parliament and the courts. By the 1600s, though, tensions explode over the instability of who had the most power. These tensions grew so high this led to the English Civil War. King Charles I clashes with Parliament over money and authority, believing he had divine rights. Parliament disagrees and the war breaks out. The outcome is extraordinary and the king is tried and executed.
England briefly becomes republic. The monarchy does return later, but it is much weaker.
And this leads to the Bill of Rights in 1689. It firmly limits royal power and strengthens Parliament, creating parliamentary supremacy.
By the 18th and 19th centuries, modern UK law really seems to take shape. You've got common law, Acts of Parliament, professional judges and lawyers. As the British Empire expands, these legal ideas spreads globally.
But at home, pressure grows for social reform. It was a time of campaigning for workers' rights, women's rights, welfare and education. Law then becomes less about property and punishment and more about society.
So today, UK law comes from three main sources: statute law, which are Acts of Parliament; common law, which are judge-made law-based decisions based on precedent; and then you have secondary or delegated legislation, rules made by ministers under authority given by Parliament. So, let's talk about law and how it's actually made today. Let's buckle in. A law usually arises as a result of an issue or a problem in society. These can arise from crime trends, public pressure, manifesto, promises, or court decisions.
The public can also create a petition on a certain issue if they wish for a law to be made or altered. If it's approved by the government and receives over 100,000 signatures, it will be considered for a debate in Parliament.
I'm going to interrupt you again. I think we should have a quick look to see what's actually available currently in the government, because people don't know about this, because I think it's 10,000 signatures and the government have to approve it, and then it's 100,000 to actually go up to Parliament, isn't it?
Yeah.
To have a look. So this says that there were 274 petitions from the current Parliament have been received and actually had a response from the government, and there are 50 petitions from the current Parliament that have been debated in the House of Commons, which we'll talk about in a minute and how they've got there. But one of the petitions that are currently being looked at, it's only got 126, it's got 120 signatures in the last hour actually, is whether they should launch a review into the airport terminal drop-off charges. Here's one that's got over 10,000 signatures by the look of it, 'cause it's gone up the grid. It says there should be a requirement that female CPR mannequins need to be brought into first aid training programmes by the looks of that. But if you go and have a look on the website, you can have a look. But that's where, if you want to introduce a petition, you need to go on the government website to do it. Yeah. So let's talk about the bill. The idea becomes a bill, and it's drafted by legal experts and then entered into legal parliament. So going back to what we were just talking about, if you've got an idea that needs to go in, or I don't know, it might be an MP that's brought it forward, it will become a bill that is drafted and then goes into Parliament for debate.
Most bills start in the House of Commons, but they do sometimes start in the House of Lords.
Any member of Parliament can introduce a bill. They do this by doing the first reading, which formally introduces the proposed law to all the ministers in Parliament.
Then comes the second reading, which is the big debate about whether the bill is a good idea. Members of Parliament will agree or disagree and argue their reasons, which is what you see on TV.
Which leads to the committee stage, the Public Bill Committee of about 17 to 20 MPs who look into the bill with detailed scrutiny, make amendments and add their expert input.
The bill then goes through the report stage, where the entire House review and examine the updated bill. They debate and vote on any further proposed changes, and then they progress to the third reading, which is the final brief debate. Members then vote to pass or reject the bill in its final form.
It will then ping-pong between the House of Lords and the House of Commons, and they will carry on debating this until it's actually made into a bill, and they will either take a final vote to accept the bill or reject it. So it'll either become law or it will not. Once both houses have agreed and the law has been approved, it then has to go up to the monarch for approval, and this is known as royal assent.
At that moment, when the monarch formally agrees it, the bill then becomes an Act of Parliament.
Probably a good example of this would be one that's gone into the news, was up in the news lately, is I can't think what it's called now, about the people committing suicide. Taking your own life.
Like euthanasians.
The euthanasia one.
And another one was the Dangerous Dogs Act that's just come recently.
Because the euthanasia one has got its past first reading stage. Yeah. And is now being reviewed again. But passing a law then isn't the end of the story. The courts and the legal professionals then have to interpret what the law actually means in real life and then apply it into their work. As you can tell, there are lots of different laws. There's lots of different areas, lots of different professions, and we all work in that, as you well know, as a family paralegal. And those laws have to then be interpreted by us and what works, basically.
Yes, and which is why different cases have different outcomes, because different judges will interpret the law differently.
Absolutely, and I could interpret something completely different to what you interpret the meaning of. So it become quite a challenging thing in a legal career.
Now, just to complicate the matters, the UK isn't actually legally uniform, so let's talk about devolution. Devolution in the UK refers to a transfer of certain powers from UK Parliament at Westminster to the devolved governments in Scotland, Wales and Northern Ireland.
That process really took shape in the late 1990s. Following referendums, the Scottish Parliament, the Welsh Parliament and the Northern Ireland Assembly were established. Each of these bodies can make laws in specific policy areas. For example, health, education, transport and justice in Scotland are devolved in these areas.
But not everything is evolved though. Some powers are only reserved to Westminster. Things like defence, immigration, foreign affairs and the Constitution.
Scotland has its own legal system and parliament. Wales and Northern Ireland have their own assemblies, which means laws can differ depending on where you are in the UK. For example, university tuition fees, I know it's much higher. Mine were much higher than what yours currently are. Prescription charges, England charge, Wales don't. And even aspects of criminal law can vary.
To sum up, devolution in the UK distributes legislative power to Scotland, Wales and Northern Ireland, but Parliament at Westminster remains legally supreme. But what makes UK law unique?
UK law actually has no written constitution and is heavily reliant on precedent. Parliament is the centre of all lawmaking decisions.
Centuries of history are baked into modern day law.
UK law is deeply shaped by conflict, compromise and change.
And whether we notice it or not, it affects all of us, everywhere, every day.
Thanks for listening.
Thank you for listening to Lawyers Who Lunch. Don't forget to follow us on social media on Facebook, Instagram and TikTok. If you have any topics you would like us to discuss or any other questions, don't forget to email in at lawyerswholunch@outlook.com.